right. Thank you all so much for joining us today. We are discussing dispute resolution processes in special education, resolving disagreements with the wonderful Kelly Wojcik from the Nebraska Department of Education. We're super excited to have her with us, and I am going to let her take it away. Did you want to say that please let's hold questions till the end. We are recording this, and we will take questions towards the end. So you will be able to write them in the chat or unmute and ask them then. All right. Thank you, Kelly.
Thank you, Jen. As Jen said, I am Kelly Wojcik. I'm from the Nebraska Department of Education, Office of Special Education. I have the unique privilege of being the manager of all things dispute resolution. Jen asked if I could come and speak to you all about all of those dispute resolution processes that we have in special education. So when there is a disagreement with special education, that you have some tools in your toolbox to help get those resolved. I will go ahead and reiterate what Jen had said before, in that go ahead and hold your questions till the end so we have a good, solid recording. So parents who aren't able to join us at this time can watch at their leisure later and not have the disruption of questions in that presentation, but can choose whether or not they want to listen to the Q&A afterwards. So that's a little bit different from me, but we're going to go with it because it makes sense for the recording, and I'm appreciative that Jen had thought of that beforehand. So we're going to go ahead and delve in right away. And as we take a look, really for the course of the hour, what we're wanting to do is really focus in on those dispute resolution processes that are available to all members of the IEP team. And some are specific to just you as parents as part of that IEP team. And all of the dispute resolution options that we have available in the state of Nebraska, as well as countrywide for the most part, is facilitated IEP meetings, and we'll talk a little bit more about that in a moment, mediation, of course, state complaints, and then due processes. So let's dive in. Before we really get into those options, anytime that there is a disagreement amongst the IEP team, it's always best to work within the team first and really address where that conflict is happening with that individual. So when there is some dissatisfaction, that there's some misunderstandings and disagreements, our first course of action is always request an IEP meeting. So the team can really hash out those concerns and discuss them as a group, because 9 times out of 10, the things that are being disagreed about really do need to be decided by the team as a whole, of which each one of you is a crucial team member. Now, sometimes even with having that reconvene of the IEP, we see that there are some disagreements that continue to fester and bubble up. So we really see dispute resolution as a hierarchy, starting with the one-on-one communication. And just like we do in a business situation, we then kind of run it up the chain. So starting off with that teacher, moving it up to the principal, moving that to the special ed director. And in some cases, it does have to go to the superintendent. And just knowing what that flow is, and that there are multiple people who are aware of the issue and trying to problem solve through those issues so they can be successfully resolved. Now, sometimes despite our best efforts, trying to address issues and concerns one-on-one and or in the IEP team are not successful. So then what? And that's what the bulk of today's presentation will be. As we look to special education, and again, we're speaking specifically about issues within the special education experience of our students. And here is where there are a variety of processes that are involved that parents as well as other team members can take advantage of to resolve those issues. And those, of course, are mediation, state complaint, and due process. And some of you may be thinking now, wait a minute, because you said something before about that facilitated IEP thing, and that's true. When we're looking at dispute resolution options, these options are specific to rule and IDEA. Facilitated IEP is what we call an option, but it's not codified. It's not in law. And there are many states in the country that do utilize dispute resolution options that aren't in law, with facilitated IEP being one of those. So what am I talking about when I'm talking about a facilitated IEP? As I said before, it's not in rule, it's not in IDEA, and it really is adhering to that IEP process and leaving IEP team decisions with the IEP team. What it does is it puts forth a facilitator, so someone who is extremely adept at managing meetings in which there is conflict and ensuring that voices are heard. So if you've ever been in a situation in which you feel like you're bringing issues to the IEP team and you don't feel as though you're being heard, and I know this has never happened to anybody, but if you're in a situation in which you feel like your voice really is not being heard at the IEP team, and as a result, decisions aren't being made on behalf of your child, a facilitated IEP is one way to tackle that situation. What the facilitator is able to do is make sure that each and every team member's voice is heard, and that each and every IEP team member understands what the others are saying. So anytime there's a communication hiccup in that IEP team, and you're feeling like, what's the point in having another IEP team meeting because we've just had one and they're not hearing me? This might be a signal that having a facilitated IEP may be helpful, because it allows each member of the team's voice to be heard. Again, this is a free service that's available to every district across the state, but it is a voluntary process, meaning that both you as a parent and the district as the other remaining team members have to agree that this would be a excellent strategy to ensure that the IEP process is a seamless one and that student needs are being met. Just a little bit more about our facilitators. Generally speaking, our facilitators are neutral individuals, meaning they are not part of the IEP team. Generally speaking, we prefer to use facilitators that aren't part of the district. That way, they really are bringing that neutral perspective and can hear and facilitate for both sides, to participate and facilitate all members' thoughts and ideas in that meeting. All of the facilitators are trained, and they're trained specifically in effective communication. And they're also trained in the IEP process to ensure that that agenda is structured in a way that it flows legally, meaning that we're talking about all student needs well before we're identifying and talking about placement. And a lot of times in heated IEP discussions, that conversation gets flipped. So they're there to ensure that the IEP happens in quote unquote the right order. Not that there is a right order, but making sure that there's a logical flow and that everyone's needs and wants are expressed during that meeting to ensure that student needs are being met once that document is generated. One key thing to keep in mind is that facilitator does not make decisions about the IEP itself. That is still in the hands of the IEP team and all of the members sitting around at that table to make decisions on behalf of that child. Now, a lot of times we think about dispute resolution options as a hierarchy. And there is an order, so to speak, but you don't have to have a facilitated IEP before you take advantage of any of the other dispute resolution options. We think of them in this order because they're considered to be the least antagonistic to the most antagonistic, if you can think of them in that frame, and that's probably not the right frame of mind to think of them in. But there's definitely more weight on some of these processes than on others. So the next piece of dispute resolution, and this piece is written into rule and IDEA, is mediation. And mediation, very similar to facilitated IEP, is a voluntary process, meaning that both sides that are involved in the dispute have to agree to mediate. When we talk about mediation, again, the similarities is that it always involves a non-biased person. And that person, again, is specifically trained in mediation techniques. Now, here's where we get into a little bit of confusion, in that districts in and of themselves are required to have dispute resolution options. And most of our districts do offer mediation. However, when we're talking about special education and we're talking about mediation, that is outside of the district and is required to go through a mediation center. So going through the district's mediation process isn't in and of itself mediation for the purposes of resolving a special education dispute. I know that parents in the past have gotten frustrated because they've said, hey, we've gone through mediation and it wasn't successful. And what we've later come to find is that mediation was the in-house district mediation, not mediation with an official mediation center by trained and truly non-biased partisans to facilitate those agreements and conversation. I will point out on this slide that we do have some resources available to you. There is a link to our slide at the Nebraska Department of Education, Office of Special Education, about mediation. And probably most pertinent to you is the slide on this, or the link on the second bullet, which is a link to our mediation centers. So if you are actively engaged in a dispute with your district, and you're thinking, hey, mediation sounds like it may be successful, this will show you the mediation centers that are available throughout the state and how to reach out and make that contact. All right, just like our facilitators, mediators also have specific requirements. And again, that they are specifically trained in communication and conflict resolution. And really the goal of the mediators is to help bridge that gap between what the different parties are wanting for the student. A lot of times where that conflict really comes into play is that parents have an idea of what is best for their child, and the teaching staff at the district feel they know what is quote unquote best for the child, and what everybody's ideal of best isn't lining up and causing that conflict. So then it's really coming down to what is legally required, and that is what is most appropriate for the student. And it is the mediator who's really pulling back all of the layers and all of the conflict to come to an understanding of what the parent's vision of appropriate is, what the district's vision of appropriate is, and trying to put together an agreement that maybe neither side is happy, but it's a decision that both sides can live with and benefit the student. So with mediation, it's not who wins, who's the successor in the argument, but it's really what can both sides live with on behalf of the student. And it might be that as a parent, I'm not happy with the resolution, but neither's the district. And sometimes both people being unhappy, but being able to put forth a plan to benefit the child is what's needed. So keep that in mind. At the end of mediation, if the parties are able to agree, and I'm going to stress the if, because not all mediations are successful, but if the team is able to agree on an action plan for how to continue moving forward to ensure that the student is getting their needs met, that will be put in writing, and both sides will be asked to sign that agreement. That agreement is then legally binding. So if the district is not upholding that agreement, or you as a parent is not upholding that agreement, either party can take the other to court and settle it, because that's then a contract dispute. So there's a lot more power and oomph behind mediation than there is for facilitated IEP. So hopefully you can see that these are kind of layered on top of each other, and that there's more strength behind the dispute resolution process as we go through these things. Next, we come to a state complaint. And this again is specific to special education disputes. And this again is written into rule and IDEA. And I should have mentioned this earlier, and I didn't, so I apologize. But you'll notice that we have two different rules here. One is Rule 51, which is school age, and Rule 52, which is early intervention. And when we have our dispute resolution processes, it does bridge both. So regardless of whether you have a newborn, a toddler, not quite 3-year-old, all of these processes apply just as much as if you have a student in a school building. And again, when it comes to state complaints, again, there's nothing that ever dictates that a parent has to take advantage of any of these dispute resolution options. They're all voluntary. They're all options on the table to help you resolve any disputes that are happening. Just as the other processes, there's no fee associated with filing a complaint, asking for a facilitated IEP, or engaging in mediation. What we want to ensure is that regardless of your socioeconomic status, your gender, your race, ethnicity, that you have access to all of the options available to you to resolve those disputes. Because again, bottom line is we want to ensure that students are getting what they're needing. Here's where things start getting a little bit more nitpicky, in that there's not necessarily a quote unquote statute of limitations for facilitated IEP or to have a mediation. You know, if something happened when your child was in early intervention and it's still nagging at you and causing you to be distrustful of a district, those can be handled with a facilitated IEP or a facilitated IFSP or mediation at any point in time. Where time starts to be a factor is with a state complaint. And that is, if you decide today that you want to file a state complaint, we are bound by rule, both rule and IDEA, with how far back we can address those concerns. So if you were to file today, December 5th, 2023, we can only look back so far as December 5th, 2022. If it happened back in November in 2022, we can no longer look at it. It's outside of what we are allowed to look at by rule. So if you have a concern and you feel that you should be filing a state complaint, keep a close eye on dates, because once they are older than a year old, we're no longer able to investigate for a state complaint. So keep that in mind. As we talk about state complaints, there really are two different facets to a state complaint. One is that it is very student specific. And as a parent, if you're having concerns with how things are going educationally for your child with a disability, you're going to think, well, of course it's going to be student specific because it's going to be about my student, right? And that's okay. I'm mentioning these differences because we know that families talk to families. We also know that staff talk to staff and districts talk to districts. And we do have situations in which we have some very observant people who have concerns that grow. And regardless of whether or not you are a parent of a student with a disability and it is your child you're talking about, or you have concerns with, for example, a classmate that your student is involved with, and you feel like things may not be going on behalf of that student the way they should, that would be a non-student specific concern. And we'll talk about that in just a little bit. Again, when it comes to student-specific state complaints, that can be filed whether your child is early intervention or in special education. And there are specific requirements for what qualifies as a state written complaint. And that includes all of these items that are bulleted here, which includes an allegation or a statement of what the district or the agency did wrong, and some facts to support that allegation. We also then request that it is a signed complaint. Now, in the world of technology, a signed complaint means it's coming from your email, and that's accepted. So you don't have to sign a piece of paper, take a picture of it, and send it to us. That's not required. If you send us an email, that counts as your signature. Here's where it gets specific to a complaint on a specific child, and these are unique to when it is a specific child complaint, and that is we have the name of your child and the school that they are attending. We have a description of the nature of the problem or the violation, including facts and documentation, which is very similar to those first two bullets. We also are requesting a proposed solution to the problem, and that is to the extent that it is known. So your frustration may be at the point that I don't know what to do to fix it. I just need it fixed. And that's okay. If that's the point that you're at, unfortunately, just put in writing. I don't know how to fix this. I'm looking for help to get it fixed. And we'll take that into consideration. You are required to file it with the department and with the district that you're struggling with. And again, sending that email to Amy Roan, all complaints are going through her, and to the district, that suffices. Here's where those district nuances get in the way sometimes, because parents will file a complaint with the district that doesn't always come to us. So you may have filed a complaint with the district and their processes, but there's nothing that requires that district to send the complaint to us. So if you want us to intervene and you want the Office of Special Education to do a formal complaint investigation, we have to receive a copy of that. And to even begin, the copy of that complaint then also has to go to the district. So they're on notice that there's an issue that needs to be resolved. Now, notice I said this is for things that are student specific. And I said that there was another kind where it's not student specific. If it is not student specific, we don't have to have a resolution because it's going to impact multiple students. For example, when you drop your child off at school, school starts at 8 o'clock, and you're noticing that as you're coming out of the building because you saw another parent in the hallway and you're chatting in the hall, so you're not getting back to your car until 8:30, for example, and you're noticing, the bus with all of my sons or daughters' schoolmates is just now pulling in. They've missed instruction. Now, you may or may not know who all is on that bus, but you know that those students are not receiving the same time at school as everybody else. That is a special education concern, but it's not necessarily student specific, but it can be investigated and addressed. So that's the difference. Now, you may or may not have a resolution to that, but it's not required when it's not student specific. And this is where, again, we get the option to get complaints from multiple facets. Anyone can file a complaint. And when it is not student specific, we of course don't have to have a student's name. We don't have to have teachers' names or anything like that. It's just, hey, something's not right. Here's an example of what I mean when I say it's not right. It still has to be signed. We can't accept anonymous complaints. And again, it has to be filed with both us as well as the district that is assumed to be the issue. And hopefully you see the differences between those. We will investigate both as long as they are signed complaints and have the required elements that I was showing on the screen. Some additional information about state complaints. As soon as we receive the complaint, as long as it has all of the requirements according to rule and IDEA, we will assign an investigator, and that kicks off what we know as the 60-day timeline. From that point, we have 14 days as an office to inform both you as the complainant and the district as the party of the complaint about what specifically we are going to be investigating. So in your complaint letter, if you say, hey, my child's IEP isn't being implemented, the IEP isn't designed to meet my child's needs, and the district is making placement decisions and they're not asking me for my input, okay? Those are the issues that we would be investigating. What we then do is put the rule that applies to each of those scenarios within that to help focus the district on their response. And we'll talk a little bit about that in a moment. If you're in a situation in which you are writing a complaint, you do not have to go into rule and give us a rule number. That's not what we're asking you to do. We know you're not lawyers. We know you're parents. So just tell us in the best words that you have available to you what's going wrong and give us some facts to support it. So in my example, they're not implementing my child's IEP. That's the allegation. I don't need the rule number. How do you know that's not happening? Teachers are supposed to provide him notes. I haven't seen any notes come back. He had a test to study for. I asked him for his notes. He said he didn't have any. That's enough fact. We can investigate based on that. IEP is not designed to meet my child's needs. That's the allegation, okay? So what are some facts to support that? My child is having some behavioral difficulties. There's no behavior intervention plan. He gets sent out of English class every day after the first 5 minutes of class. And by the end of English class, they're calling me on the phone and telling me to pick him up or her up, okay? To me, that's enough to say, what's not happening for this student that is causing him or her to be sent out of the class and more so to be sent home. That would be an IEP design issue. The placement thing. Hey, you know, the district is making placement decisions and I have no say in it. Okay, so some example facts may be, we had an IEP meeting on such and such a date, and they immediately started talking about this level 3 program over here. And I told them, no, I wanted them to stay in the special education resource room. And I was told that wasn't an option, and they placed him in the level 3. That is sufficient facts for us to be able to start that investigation. Because again, we need the allegations, we need facts to support. Now, when an investigation is launched, we always provide an option for the parties to engage in mediation. And notice I said option. It is both your choice as well as the district's choice if once the complaint is filed to engage in formal mediation with a mediation center. It is not required. And we'll get back to that in just a moment. If you're in a situation in which you have filed a complaint, the complaint letter just has to be that. The allegations, the facts to back those allegations, of course, contact information, all of those bullet points, and a resolution. You do not have to provide to us in the email starting the complaint all of your evidence, and I'm going to formally call it evidence. We don't need that. The district does not need that. That can come later. We don't want to bog you down in getting the complaint filed because we know 60 days is a long period of time for a student to be in a situation in which they're not getting what they need. So if you're in a position where you're feeling like you have to file a complaint, get it filed. Give us the bare minimum of what is required to file a complaint and refer back to those bullets. All of the evidence, all of the proof, all of the diligent notes that I know you're taking at home, all of those can be provided later. And you'll have a letter that details, this is what we're investigating. And it will give you a link to say, if you need to provide us more information, use this link. That's your chance to provide us all of that other stuff. We will ask the district for very specific documentation. We do not require parents to provide us anything specific other than what they already have available to them. So if you feel that there's a difference between the IEP that you were handed at the end of the meeting and the IEP that a teacher is referring to in a parent-teacher conferences, and you're seeing a discrepancy between those two, you can say, hey, this paperwork doesn't match, and here's my copy. So when we see the district's copy, we can see, yeah, those don't match. And there can be corrective actions associated with that, quite potentially. But don't feel like you have to have all of those pieces of paper and information collected and ready to submit to us when you provide your letter of complaint, because it's not necessary, nor is it required. You have an opportunity to provide that wealth of information and documentation, if you have it, at a later time. We don't want that to be a hurdle to you filing a complaint. Now, we've talked a little bit about some roles, and I had said before that the district will be provided a specific list of things that we want to take a look at to investigate the complaint. As a parent, your role is to recommend a resolution. This is how I want this situation fixed. You have a responsibility that you can provide us documentation. If you don't have it, that's okay. Don't worry about it, but it is available to you. So if you have something, provide it to us. The district also has responsibilities. They also can recommend a resolution. Very often a district goes, man, we really messed up, and this is what we want to do to fix it. And that's allowable. They're also going to be asked for specific documentation. What is optional is this whole concept of being interviewed or providing additional information via a survey or that kind of thing. Traditionally speaking, a complaint investigation hinges on the wealth of documentation provided by both the parents and the district. An investigator may request to speak to you as a parent if there are some outstanding questions. So they're saying, for example, with a discipline issue, they're seeing all of these absences on the part of the student, and they may just be written as that, an absence in the district's documentation. So the investigator may want to talk to you to say, okay, tell me about this absence. Was the student sick? Or did the district call and say, hey, you need to pick the child up, and by the way, don't bring them back until next week? That's very different. And they'll ask that same question of the district and have them explain what that absence was. And then again, determine what's actually happening with behavior with this child, not necessarily solely based on the documentation, but also the information that's provided by both you and the district. In some cases, it may just be the district that the investigator needs to talk to, because a majority of the questions are with the district that only district staff can answer. In some cases, they may only talk to you as the parent, because the questions that they have outlying rely with that knowledge and information that you have as a parent. It's not an imbalance. The interviews are strictly to answer and to come to some resolve over those nagging in the back of the head and questions that cannot be found through the paperwork. So if the investigator wants to talk to you, that's not necessarily a good or a bad thing. They just have questions that need to be answered. And same thing for the district. It's not a good thing or a bad thing that the investigator only talks to the district. It's just a fact that whatever question was nagging at the investigator, it was determined that really only the district could answer that question. And those are going to flex depending on the circumstances of the case. The thing that I want to draw your attention to is anything that you provide to us as investigators is not going to be shared with the district. And anything that the district shares is not going to be shared with you as a parent. And it's written in statute that we cannot share investigatory material. So I want to put it out there. So a majority of the time when we're asking for documentation from the district, those are things that you should already have in your possession. It's the child's IEP, it's prior written notices, it's their MDT, it is their discipline record. Those are all publicly available records that if you see it on the list of evidence that we reviewed and you're going, wait, what? You can ask the district for those things, because that is your right as a parent to request to view those documents. They might not copy them off and hand them to you, but they should be able to allow you in a conference room with the file on a table for you to page through and look through that information, because you have a right to that information as a parent to view it. All right, so once the investigation is off and going, we have 60 calendar days to investigate. And what everyone who is a party to that complaint will receive is a written decision, which includes the findings of facts, the conclusions that were drawn, and that conclusion includes whether or not there was a violation of law or rule based on what the investigator found throughout the course of that investigation. If the district was found to have done something incorrectly, there will be a corrective action plan that is required that the district implement. And all of that is contained within the written report. That brings us to timelines, and timelines get hairy. Some timelines are flexible, some timelines are not. The timelines that are not in any way, shape, or form flexible are that when you're filing a complaint, we can only look back so far as a year. If you are complaining about issues that are more than a year old, they will not be investigated. That's a hard and fast rule. We have no flexibility on that whatsoever. We also have 14 days to provide to you a letter detailing the investigation. These are specifically what we saw as allegations in your letter. These are the things that we are investigating. We have 14 days to get that done. If at the conclusion of a complaint investigation, a district is found to be out of compliance, meaning they've done something wrong, they have 365 calendar days to get it fixed. That is an immovable date. It is not flexible. Everything else is flexible, meaning we give both you and the district 14 calendar days to provide us documentation that we've requested. And again, that request is specific to district documentation. It's not specific to things that you have to provide. We request those in 14 calendar days. If your child becomes ill and you're at the hospital or that kind of thing, and you tell us, hey, I just need an extra 5 days to get you this stuff, generally speaking, we're to say yes. We're not going to disrupt that flow of information because we know you have things that you want to share with us, and we want to give you that opportunity. But the sooner we get that information, the better. We've had some situations in which parents wait until the day the report is due to give us stuff. That's too late. At that point, it's not going to be considered because we have to release the report after 60 days. Now, for those of you who have already seen, you said, now, wait a minute, 60 days you say is negotiable. Notice the asterisk there. And that 60 calendar days is negotiable to a point. And that is OSEP, which is our federal partners that have requirements that we have to uphold, are very specific under the rules on which we can extend timelines, and they are very strict. If, as a parent and a district, you determine that, hey, I think we can mediate this out. We can talk with that non-biased party at one of the mediation centers, and we can agree to something. But you know what? Our schedules are hairy because it's the holidays. So can we extend the investigation timeline by 15 days? That we can do. But both you and the district have to agree to extend that timeline and give us, this is when we'll have it wrapped up time. Okay. It cannot be, well, we don't know how long it's going to take, just extend it. That we will not do. So there has to be an agreement, and there has to be a set date for which it is going to be wrapped up and done. Now, let's say you engage in mediation and you've asked for a 15-day extension, and we're getting close to the end of that 15 days, and you're still going back and forth in mediation. Both you and the district can then come back together and say, hey, can we have another 15 days? And we can do that. But if we don't have the request, regardless of what's happening with mediation, that report will go out on the quote unquote due date regardless. So we can extend, and we can extend for mediation, but there has to be a specific date that wraps it up. And that's important because, again, we know that during this time, your student may not be receiving the services that he or she is required to have to be successful in school. So we don't want to extend this and start piling on missed time because of negotiations. Okay, now there are a few other pieces that will allow for an extension on the mind of OSEP, and they're pretty significant. So if, for example, we reverse our time and we go back to all of the lovely floods that happened not too many years ago, that would be a prime example in which we may need to extend the timeline because everything's flooded. No one can get into buildings. Technology is short, that kind of thing. So there are some exceptions to mediation, but they're very rare. The other negotiable timeline are the corrective action timelines within your investigation report, meaning if a district was found to be doing something wrong, we may specify things like you have to reconvene the IEP, and we'll put a date for when that IEP has to be reconvened. That specific date is negotiable. So the district may say, hey, state, that timeline is right in the middle of the holiday break. Can we get it done by, and they'll give us a new date. More often than not, we're going to accept that. Those internal timelines are flexible, and that's to ensure that we're not leading the district into additional non-compliance because of a timeline. All right, moving on to due process. And this is the last dispute resolution option within Rule and IDEA. Due process is very much a legal proceeding. State complaint, although it feels legal, is not legal. I'm not a lawyer. I don't play one on TV. I'm just someone who is knowledgeable about special education law that has a passion for ensuring that students get what they need to be successful. When we're talking due process, that is in the hands of our legal department. That is in the hands of lawyers. And it is highly recommended, it's not required, but it is highly recommended that if you are filing due process, you are having legal counsel assist you in that process, because the district will have their lawyers on it, and that creates a bit of an imbalance. It is much more a legal proceeding, and that it is, in a lot of ways, court. You will provide evidence and documentation. The district will provide legal evidence and documentation, and the two sides will argue in front of the hearing judge, and the hearing judge makes the decision. Here, the statute of limitations is a bit longer, and that you have 2 years. So with complaint, we could only look back 1 year. Due process buys you another year. They can look back 2 years. So keep that in mind. What is also different between a state complaint and a due process is that a state complaint can be filed electronically. And in fact, it's encouraged to be filed electronically. Due process, that is not the case. It must be a hard copy only. You have to physically mail in the papers with the petition that is signed. And very similar to a state complaint, it's still going to include the name and address of your child, a description of the problem, the proposed resolution, and that is going to the district as well as the Nebraska Department of Education. Here's the difference. That's going to the Nebraska Department of Education legal office. State complaints come to the Nebraska Department of Education Office of Special Education, 2 different offices. For due process, usually you'll receive something in the mail within 10 calendar days, so it's a little bit of a timeline change. And whether it's you responding or the district that's responding, they're going to be responding to these specific questions. So they're going to be doing some explanation of what was in the complaint, what the team had considered and why that wasn't acted upon, and all of that information. Once we have it, there's a meeting usually within that 15 days for a resolution meeting. And either you or the district can decide, nope, we're done, just bring it to due process, and that it will go to due process. That due process hearing officer is pretty much assigned at the moment we receive the due process hearing. And it is that hearing officer that's keeping track of all of these other internal timelines that are written into rule specific to due process. Now, where things get a little bit hairy is when there is a due process and a complaint that are filed at the exact same time. And yes, you can file both. What's different is that only the issues in the complaint that are also in the due process are put on the side and ignored, and they go through with the due process. If there are different issues in both, then both will take care of those issues. But any issues that are the same, the complaint investigation will be ignored, and they'll only go forth with due process. And it is the issue that is set aside, not the complaint as a whole. And that is the confusion.
Kelly, this was so great. This was such good information.